All rise. Court of Appeals Division 1 is now in session.
Morning. You may be seated. Morning, both of you. We are here on our case number 1 CACV 170238, Cincinnati Indemnity Company versus Southwestern Line Constructors Joint Apprenticeship and Training Program et al. 20 minutes. Keep track of your own time. Please give us your name and name of your client when you approach. You know this. We've read the briefs, we've looked at the record, and we've discussed the case in our conference. Mr. Bain.
Good morning, Your Honors, and may it please the Court. Judge Perkins, I don't believe we've met before. Nice to be in your courtroom. My name is Scott Bain. I represent the defendants in this declaratory judgment action to determine whether, in a nutshell, there's $1 or $2 million worth of coverage available under Cincinnati's CGL portion of their policy to my client Southwestern. I'll get into the Helm and its causal test in a moment, but I think it's important to make two threshold points that the good thing about this case, I think for the court's purposes, there's no factual disputes. And it's uncontested, or at least not disputed, that if Helm and its causal test applies in this case, there is evidence in the two underlying cases, both of which have resolved. The only thing left is this deck action. That there were 5 independent causes of the pole falling and severely injuring my guys. I won't go through them because they won't.
So there are 5 acts, each of which arguably could have independently caused the.
Yes, exactly.
The pole,
and according to our the underlying experts, did in fact, and they were quickly the bad pole, the failure to test the bad pole. There's 2 different tests. One's a hammer test. Another one is a bore test to check for exactly the type of problem we had here, termites and rot underground. The third, or if you want to consolidate all those in one, there's what I call a fourth or at least a second violation of the standard of care, which is the failure to use secondary support. Keep this up. And that when you're taking these wires off the poles in the pole yard, if you're taking all the tension off, which is what they do, they call it wrecking it. You got to use secondary support regardless of whether there's any rot. So that was a separate independent problem. And then, of course, the last one was failure to supervise these 2, well, all the apprentices, but these 2 in particular. And defense, or I guess it's my client now, Southwestern admitted that they really failed these guys. Okay. So it's a sad situation, none of which has really anything to do with the here because the damages are not at issue. All of those are independent. The second prefatory point is that if the causal component of this policy were in the definition as opposed to moved over into the coverages section, then I don't think Mike's client, he certainly hasn't done it in his briefs, disputes that there would be $2 million in coverage. So
How would that read? How would that read if the causation component were moved into the definition of
well,
occurrence?
I think it starts with Helm, because in Helm we had, and this kind of is my argument in a nutshell of what we're up here on. In Helm, the definition of an occurrence, and this it's important to keep in mind that this is a per occurrence policy as opposed to a per person policy. Different types of insurance is written in different types of ways. That's the 2 general ways. This is a per occurrence policy, unlike the Green case that they cited, which was a per person policy. 1 person, 15,000. In Helm, the definition of occurrence was that an incident or a series of acts together resulting in an injury, bodily injuries, And Helm went up, and the Feldman Court back in whenever it was, 83 or whatever, interpreted that with the majority view that when you have an occurrence-based policy for which coverage is determined based on causation, they use the word resulting there, it's causation here, caused here, but Helm interpreted that as the language resulting in as a causal component. In that situation, you determine the number of occurrences by determining the number of independent causes of the injuries. And in Helm, it was 2 docs, one of whom failed to look at the x-rays one day, one of whom failed to do it the next day. And they came up with 2 different things, or 2 different occurrences in that case. Here, we have a different definition of occurrences. And that's been the defense position, and frankly, Judge Gerlach's position from the get-go. The definition of occurrence in this situation is different than in Helm because we don't have a causal element, either using the words cause or, as in Helm, resulting, in this definition of occurrence. Well, yes, that's true. I can read. I'm not a complete idiot. The issue here, and the rub, I think, with existing Arizona law is my argument was that they simply took the causation element out of the definition and shifted it over to the coverages section, a couple pages back. My argument was that they did that to get around Helm or the subsequent unpublished case that we can't talk about, which followed Helm and which really, based on the facts of this case, there's really no dispute that if the Helm test applies, there's multiple occurrences, at least 2, which gets us the 2 million. Now,
here's the thing, though. Here's the thing. I'm wondering if the real rub is that this is what we have here is an accident policy. It's not an acts or omissions policy. And even if you move causation into occurrence, it would have to read injuries caused by an accident.
yes.
And there's only one accident here.
Yeah, but it's no different than in Helm, where instead of that was obviously a med mal policy, where the triggering it was incident resulting in. Here we have accident caused by, and I think
Injuries caused by an accident.
yes,
Yeah,
yes,
okay.
yes, and I don't think there's a realistic difference, or certainly a legal distinction, between an incident and an accident. In incidents, I mean, I don't think any of us call med mal negligence to be an accident, although it certainly isn't an intentional tort. It's accidental. And same thing here. They could have used incident. I don't think there's any realistic difference between the two, certainly in this kind of case, between an incident and an accident. But the key is, and I think Mike will concede this, and they did on pages 19 and 20 of their answering brief, that the causation element of Helm is contained here. And it's just shifted over to the definitional section, or to the coverages section, so that both in Helm, by looking only at the definition of occurrence, and in this case, by looking at the definition plus the coverages section, you absolutely must have an accident that caused the injuries, caused the bodily injuries.
What's the authority for the proposition that we need to read a policy that talks about an accident to mean incidents, acts, or omissions? I mean, there's a lot of, you know that there's a lot of case law about unexpected and unintended and sudden and accidental, and those are terms of art. How can we just assume that one means the other?
Well, I think, well, first of all, there's no definition in the policy. There wasn't a definition of incident in Helm, and there's not a definition of accident here. So I think you just have to, go
But
kind of.
it's hard to argue that one of the underlying acts would be an accident before there's actually the event, the accident. It's hard to pigeonhole any other definition other than the event, the accident. Seems different than the incidents that led to the accident.
Right, and my answer to that, and I think this is where Judge Gerlach went, is that there's only one accident, there's only one accident, there's only one accident. To the point I thought he was going to hit me with a stick. But and I guess that argument was made in Helm that there's only one death. Both of these resulted in one death. And that's where Helm went off on this argument that, yeah, but there's really two incidents that resulted in the death. And in here we have 5, or at least 3, if you want to cram all the first 3 into one, which are kind of sort of the same. Testing, we'll say.
Inspection, okay.
Yeah. We have those 3 which caused the injury or the accident. And as in Helm, there was only one death. Here, there's only one accident, but there were 5 acts here, 2 acts there. So the analysis of Helm is right on. And I understand, first of all, the defendants never really addressed this. I mean, this was kind of where I've been involved in this case since the get-go, so I was kind of setting up to get here today on this issue. Both in the trial court and in the answering brief, the answer has been the definition is different. Yes, we'll give you that. But there is a rub with looking at the whole policy, both from our 40 years of case law on this, going back to whenever the heck it was, and I cited a bunch of cases on that, and they didn't dispute them. How can you dispute them? But also we have a statute that basically says the same thing, that was 20-1119, that says all these policies need to be construed as one, that you can't parse different things, which, and one of the cases, if you don't want me to talk about this, tell me to stop, because this is the Judge Snow's district court case, and I've cited it in the trial court, and then I went to a seminar and said, Rule 111 applies to unpublished district court cases too, so I backed off in my opening brief, but since Mike brought it up, it certainly was discussed below, and I don't care if you look at it, it's certainly not precedential.
Do you have the site?
And the point of that is this issue, because if you just look at the case, it looks like it kills me. It's the same policy, and Judge Snow said, this is not Helm because we don't have a causation element. But there, and no one raised it. I mean, I'm the one that figured out this problem. In Charbonneau, but for the rub principle that we look at these policies as one, Charbonneau would beat me. But that was not raised there because for whatever reason. So I don't think Charbonneau really helps them on the issue of whether the court is going to be able to parse these, and I don't think you can. I've got 7 minutes left. I really don't. I mean, I really kind of spilled my guts in the briefs, so I'll wait and see what Mike has to say and come back. Thank you.
Thank you.
May it please the court, good morning again. My name is Mike Frizzell, and I'm appearing today for the Cincinnati Indemnity Company. If Cincinnati's summary judgment motion and Cincinnati's brief on appeal were a tweak, this is it. Cincinnati's policy defines occurrence as an accident. When the pole broke, there was a single accident. One occurrence, one accident. Even the appellants at the oral argument on the motion for summary judgment agreed that there was a single accident. That's the tweet. I have more than 19 minutes left, so the next thing I'd like to talk about, with the court's indulgence, is why the definition of occurrence is so important from case to case, including this one, and why the fact that occurrence is defined in this policy as being interchangeable with the word accident is so important.
As opposed to an incident, act, or omission.
Yes.
I'm
yes.
curious about whether there's a distinction.
Okay, great. Just to speak directly to that for a moment, as we argued in our briefs when the appellants said, well, there's really no difference between an incident and an accident, we argued in some detail why an incident is broader than an accident and could involve different degrees of conduct than that which is classically defined as an accident. And the language, for instance...
When would it ever be actionable if it didn't result in an incident, an accident?
You mean in terms of a liability insurance policy, or
The preliminary things that you're talking about that you're saying are not necessarily covered if we're just limiting it to an accident.
well, the classic example is the basic insuring agreement. What my colleague is referring to is the coverage section of the policy, the initial coverage grant. The basic insuring agreement indicates essentially that a policyholder who's found legally liable because of bodily injury or property damage, which occurs during the policy period, during the coverage term, and as a result of an occurrence, is covered. Much like my tweet, that's about 1% of the insurance policy. The rest of it is limitations, exclusions, and some endorsements that also expand coverage. Or in some cases, which I'm sure give all of us headaches, it giveth, it taketh away, it giveth some back, and it does it in a panoply of endorsements. At any rate, by virtue of what I just related to you, Your Honor, the insurance policies such as Cincinnati's are set up to insure policyholders for liability as a result of an occurrence, and in this case, an occurrence is an accident, which means an unexpected, unforeseen, unplanned event. In other words, an oopsie or a boo-boo. That is what they're intending to cover. And to belt and suspenders strengthen that point in most of these policies. There's also an exclusion for intentional acts, just so it's understood that we're not covering you for anything that you did on purpose. And of course, one of the points we were making in our briefs in the court below for why an incident is broader than an accident is because an incident could include many things that are not accidental. A cynical, tired, burned-out police detective may refer to a grisly homicide as an incident. It is, but it's certainly nothing that has to do with an accident. So it's just a broader term. And in Helm, they also talk about not just incidents, but acts or omissions. And that makes a difference when an insurance policy has packed all that into the definition of occurrence, because those are also broader terms than an accident. An act or an omission can be accidental, or an act or omission can be intentional, reckless, in some instances. All the fraud cases you all have to look at and decide, malicious, evil. And they're all, acts of or omissions of some important statement of fact in a transaction or things of that nature. So all these words that were in Helm in the definition of occurrence are simply not present in our definition, and therefore in this case. And it's pretty important, if not critical.
Is there, we can look at your briefing in the Superior Court, but is there, I can't recall off the top of my head what Arizona case would have best discussed that distinction between an accident policy and an accident omissions policy?
The GRE case is one of them. We cited more than one, but as I stand here, that's the first one that's coming to mind. And it's simply because it provides, as part of its discussion, in its opinion, just what an accident is, because that was a motor vehicle policy that had the typical language about we'll pay X per person, Y per accident if an accident involves more than one person. And so they had to talk about accident because the policy was set up per accident. So that would be one that would come to mind. And it is essentially the unplanned, unforeseen, uneventful, unplanned for, unforeseen, unexpected event. So it's event.
But that's sort of highlighting the distinction opposing counsel was drawing, that this isn't per person, this is just per event.
Yes, except the word that's used in GRE for a description of what the policy limits are and what they relate to is synonymous with what Cincinnati's done here, because if it's a certain amount of policy limits per accident and it's a certain amount of policy limits per occurrence, and if occurrence and accident are synonymous, then there you go. It's the same thing. What's not the same is any definition that a court is analyzing and writing an opinion about that involves a definition of occurrence that is not like the one that's written in this policy of Cincinnati's. And what my colleague representing the appellants seems to be saying, and forgive me, it's just argument, but what they seem to be saying is that it just doesn't matter what the contract before the court is about what the definition of occurrence is, because we've got this case from the 80s involving a different definition of occurrence that was analyzed there, and whatever was said then should apply forevermore. Well, we know that's not true because the GRE case specifically distinguished Helm because of the language in the GRE policy. The GRE case specifically pointed out that a published appellate case out of Kansas decided after Helm had also discussed Helm and distinguished it because the Kansas case involved a policy that was written where accident was synonymous with occurrence and vice versa, and it made all the difference in the world. And all of those statements of the law are in the Helm case. So that's part of it. The other part is, without getting too legalese about it, is it's almost like saying that a ball and a box are the same. And we know a ball is a sphere, and we know a box is a cube, and we know that if one were seeking to define those objects, we would do it in some manner like that. Yet both are objects. They're just different objects. Okay, Helm and GRE and Maples and just about any case any of us discussed in our briefs has a somewhat different definition of occurrence, and some are closer to balls and boxes and vice versa. But the court attempts to interpret each of the definitions of occurrence where it's a or the pertinent issue in a case by figuring out whether we're talking about a cube or talking about a sphere. And that's what we're asking to be done here, and that's what the trial judge correctly did in our view.
Are there some sorts of liability policies that are more likely to be balls than spheres, or accidents or omissions? In other words, by industry, by profession?
It's not in the record, but if the court gives me permission to answer it, I'll be happy to take a shot at it. The answer generally is yes. And what comes to mind is, for instance, a lawyer's malpractice policy or a medical malpractice policy or hospital policy may speak in terms of errors and omissions as part of its definition of occurrence because of the obvious implication of standard of care and whether one fell below it or managed to rise above it is part of what the professional liability would be.
You want to cover an allegation in that sort of situation, even if it's not an accident, because of the difficulty in.
Yes.
Yeah.
In coverage B of Cincinnati's policy, which deals with a totally different type of potential liability, the personal and advertising injury liability, it speaks of offenses, and it has a list of offenses. Virtually all of those offenses can be done accidentally, but some cannot. And yet they're agreeing in that particular coverage section for that particular kind of claim to cover some things by contract and by definition that are offenses. Another would be a director's and officer's liability policy. My goodness, some of them are so generally worded that if you did something as a director and officer, it's covered unless, and then the exclusions are few and extreme. Fraud is proven against you or something like that. So, sure, there's lots of them. That would be my answer to that question.
What kind of industry or insured would be more likely to buy an accident policy rather than an errors or omissions policy?
I can't speak to that from the standpoint of an insured or a policyholder other than personal practical experience.
I don't mean that. I mean, where have you seen it in the case law? What kind of cases discuss accident policies? Can you remember? Other than auto, but I'm talking about
sure.
GCL.
Auto, commercial general liability policies like Cincinnati's, ever since the Insurance Services Organization came out with this form. And we know on the record that this is an ISO form because it says so at the bottom of every page of the basic insuring agreement. So there's a couple of examples right there, including one that's real to this case. I promise not to talk too much more about boxes and balls, but I did just want to say to wrap that up that the appellants are just wrong if they think that we can get to the right answer in this case by saying that because all occurrence definitions in a policy are objects, it doesn't matter whether one's a ball and one's a box. It does. The courts decide these cases based on what the actual language in the contract is, including the Helm case. In the Helm case, there's a section of the opinion. I'll get the page number. Looks like it's the Arizona citation at page 135. I'll try to double check that while I'm looking, but forgive me if I'm wrong by a page or two. But the Helm case says ordinarily if an insurance policy uses occurrence without defining the term, the courts inquire whether there was but one proximately uninterrupted and continuing cause resulting in all of the injuries and damages. Right after it said that, at this page I'm thinking of, which I think is the Arizona side at page 135, right after it said it in the same paragraph, it goes on to analyze what the definition was of the imperial policy involved in that case and spent the rest of the case deciding what the definition in the imperial policy meant. And of course, as has been said ad infinitum, the imperial policy's definition of occurrence is far different than ours. And we are not just the only ones saying that, because the published appellate decision out of Kansas that's cited in GRE makes the same point, and I think uses the magic words. The definition of occurrence in the policy in Kansas, which read like ours does, is substantially different or significantly different than the definition in Helm, and it matters in terms of the contract interpretation. Another thing that was brought up by my colleague during his remarks, there's nothing in the record that indicates that Cincinnati moved, removed, or relocated any of the policy language that's in the form of coverage that was sold to Southwestern. Nothing. There's also, just so I don't forget, there's an impermissible argument raised for the first time in the reply brief of the appellants about reasonable expectations being a potential theory of coverage. That was not raised below, so I take official umbrage at that and wanted to make sure I mentioned that. There was also, as the trial court in our case pointed out, there's never been any issue raised that there's something about the definition of accident that's ambiguous, so that's not on display here. So now I have to get my train of thought back. All right. So what we do know, because it's not in the record that we moved, removed, or relocated anything, what we do know is in the record. The policy is in the record, and the policy is an ISO form of commercial general liability coverage. It says so right on the bottom of every page, as I mentioned before. That's what we know. So what's in the record about moving, removing, relocating, doing something to get around Helm, et cetera, et cetera? Nothing. What's in the record about what this policy really is? It's an ISO form.
And you're suggesting there's nothing necessarily sinister about parties agreeing to some language that's different than the language in Helm if the parties understand the word that's used?
True.
Something they contract to do.
True. We have, well, again, this isn't in the record, but it answers the question, and I'll be brief. But we have manuscript policies. The big sophisticated purchasers of insurance sometimes have the power over their own insurers to truly arm's length negotiate these things. And there you will see any number of things that you wouldn't see in, for instance, an ISO form that's used much more commonly. So I've got less than a minute. If there isn't any other question I can answer, I would just close by saying that the tweet says it all, and the right answer here is the same answer that Judge Gerlach came to. Number of occurrences, 111. Why? He says so in his rulings, and they're all based on existing Arizona law. There's nothing new, different, or unusual here. His ruling is based on existing law, and he's right. Thank you.
Thank you.
For the record, Scott Boehm again. I've got 7 minutes left. Just got a few points to touch on, some, most of which are in response to what we just heard. First, I want to clarify that we did not concede that there was a single accident in this case. What we conceded was the pole fell once. But the point, of course, that I've made several times here is that it fell for 5 independent reasons. Now, I will reiterate my position that I don't think there is a legally significant difference, certainly in this case, the facts of this case, between incident and accident. So whether you want to call that boxes and balls, I think it applies to both. Go ahead, Judge. You're about to ask me a question.
I'm just trying to, so the policy in Helm incident, damages caused by an incident, okay?
Actually, two incidents.
Yeah,
in that case.
two failures.
Right. And I think you asked Mr. Fazell, Mike, a question, and he answered kind of off the cuff. He was right about this, so I'll kind of reiterate that. Your question was something about, are there different types of policies, generally different? And the answer is yes. Some of them are, like the policy I have, the policy most docs have, are errors and omissions policies, and they're more tend to use the incident type language, whereas the per person policy in the Green case, the GRE case that he mentioned, is a car accident case. They're car policies. They're more likely to use different language on the per person basis, which was the problem that Green found. And then, of course, the GCL policies like this use typically incidents. And I don't know the answer to your question any more than he did about give me a case that has it right on point.
Well, I'm trying to figure out why this is an accident policy. That's, I mean, other than the notion that
right, and I don't think it
to reduce coverage, but
to that extent, it is different than Helm, and maybe the issue then becomes the preliminary issue. Does the Helm analysis apply when the word incident or accident is used instead of incident? I don't think it does, but it and we're certainly not. And he went through an analysis that incident is broader because it can be malicious or innocent or incidental or whatever.
Something that happens.
Issue. Yeah, just something that happens. And I don't think again that's practically, in terms of practical significance, any different than accident. I mean, in this situation, could easily have been described as an incident. If that was within the definition of occurrence, and I absolutely do not suggest that we don't look at what occurrence means here.
But is your argument that each of the five acts,
whatever they
torts,
are, five instances of negligence. How about that?
Is each of those an accident?
No, but but neither would each of those been an incident under Helm, and that's where Helm says. So if we take accident out and put incident in for purposes of this argument, the analysis is exactly the same. There wouldn't be five separate incidents. The pole only fell one time. The guy or the woman in Helm, I guess it was a guy in Helm, only died one time. But that's where Helm gets into, we look at the number of causes to determine the number of occurrences. And certainly we look at the definition of occurrence here.
But the definition in Helm required the court to look at the causes.
Yes,
right? And it wasn't restricted to incidents. It was a series of related incidents, acts, or omissions resulting in injury, and we don't have that here, right?
Resulting. And that's I think what you're saying is my argument in a nutshell. We don't have it here. And the reason we don't have it here is because that causal component, the resulting in, is over in the coverage section. Now, we heard that, they didn't move it over there to get around Helm. But, okay, maybe they didn't. But the fact is, it's over there. And the reason, and they admit on page 20 of the answering brief, that it's moved over there, or it is over there, to clarify that an occurrence requires a causal connection to trigger coverage, which is exactly what was the situation in Helm. The only difference being incident versus accident. So if the court decides, and it sounded as we all talked through this, that maybe the preliminary question that you're going to have to address, that we didn't really address as an issue or bring it up as an issue, was talked about, is whether the Helm analysis applies to policies that are occurrence-based policies that require causal requirements, whether it be in the definition or in some other section read as a whole, whether the same analysis applies to accident versus incident. I think you get there. And if you do get there, then ultimately the question is, and this is the specific issue that I did raise, can they parse the policy? Can they just effectively get around Helm, whether they intended to do that or not, by having the causal component in a different section? And I just think that violates the statute I gave you earlier, 21119, and all the case law. So if you decide, obviously you get to decide whatever the heck you want, but if you decide that that Helm's not going to apply to this type of case, I think that you should do a retroactive analysis on that, because when my client Southwestern bought this policy, I'm not going to try to blow smoke and say they sat down and did a thorough analysis of what Helm said, but we all acknowledge that you take the law as it exists at the time. And if we're going to change that now to policies like this, I would request that you do it retroactively. And I'm out of time. Thank you all very much.
Thank you both for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll recess for a bit to allow the next case to set up.